Good afternoon. Today we're going to be discussing civil liberties and how it applies to AP government. So first we're going to start out talking about adaptations. We have the Sedition Act of 1798. It made it a crime to write, publish, or utter false, scandalous, or malicious material about the government. The Espionage and Sedition Act of 1917. An advocate treason or incite resistance. Schneck versus U.S. court case, clear and present danger test, and fire in a theater are examples for the Espionage and Sedition Act of 1917. The Smith Act of 1940, Internal Security Act of 1950, Communist Control Act of 1954 with Senator Joseph McCarthy. Executive Order 1966, Japanese internment court case Korematsu versus U.S. and in 1944 citizens can be detained in emergencies. Then we have the extension of civil liberties, and we mainly discuss incorporation. And incorporation is something you talk about in 6.07a and 6.07b. In 1833 we have Barron versus Baltimore, and the Bill of Rights then was not incorporated into the states, meaning the Bill of Rights were only guaranteed in a federal court case if the federal government takes away those rights, not the state. And then we have the Due Process Clause for the 14th Amendment. No state shall deprive any person of life, liberty, or property without the due process of laws. This is after the Civil War and established the equality among men. Our first incorporation of Bill of Rights is Gitlow versus New York, and that was the First and 14th Amendment. Freedom of speech, the protections of Gitlow versus New York. So that had to do with unpopular speech. We have also Brandenburg versus Ohio and the KKK. Threats must be proven to result in lawlessness. Snyder versus Phelps protects people at funerals. We have symbolic speech, Texas versus Johnson, protects flag burning, very unpopular. And then we have Tinker versus Des Moines, 1969, arms bans freedom of speech in schools. Limits, we have the clear and present danger test, fighting words, libel and slander must be proven false and malicious, and obscenities. It can be regulated by the state, difficult to define. Stewart, I know it when I see it. Definition of obscenity is the Miller test. Nudity is not obscene. It must have political, literary, or artistic merit, judged by the average community standards as obscene, such as child pornography, and content is depicted in an offensive way. Symbolic speech is less expectation of protection. Not protected is the burning of a draft card, but what is protected is the burning of an American flag. What is the difference? Who has freedom of speech? Corporations do, businesses, organizations. There are more limitations on commercial speech, and students. Students have free speech versus with Tinker Des Moines, and less speech in school, Hazelwood High newspaper we discuss in the course. Freedom of press, the Nair versus Minnesota, 1931. Nair established that states' prevention of publication is in violation of First Amendment, incorporates freedom of press, and denies prior restraint. New York Times versus the U.S. in 1971, the Pentagon Papers. The court rejected the government's prior restraint. Hazelwood School versus Kohlmeyer. School officials have the authority to prevent publication in school newspapers. Freedom of religion, separation of church and state is not clear. We have the Free Exercise Clause. Congress shall make no law prohibiting the free exercise of religion. And we have the Establishment Clause. Congress shall make no law respecting an establishment of a religion. Free Exercise Clause. Freedom of religion allows for practices if they do not harm others, but it is not always clear-cut. What is protected is animal sacrifice, conscientious objection, no license fee for religious solicitation, Jehovah's Witnesses. What's not protected is polygamy, drug use, Employment Division versus Smith, and soliciting donations. Establishment Clause. Supreme Court ruling support wall of separation between church and state, which supports Jefferson's views, and this was dictated in Everson versus Board of Education in 1947. What's not protected? School-sponsored school prayer, as we learn in Engel v. Vitale. Minister rabbi leading the prayer, Lee versus Weissman. Student leading prayer at school assembly or a game, Santa Fe Independent School District versus Doe. Prohibition of teaching evolution in schools, Epperson versus Arkansas. Taking time away from school or religious activities for religious activities. Nativity scene in local park, Ten Commandments in Kentucky courthouse. What is protected? Government aid and tax incentives to religious organizations. Vouchers for students to go to public and private schools, Zellman versus Simmons Harris. Menorah and Christmas tree outside public area, Ten Commandments in Kentucky courthouse. Prayer in Congress, In God We Trust on Money. Chaplain in armed services. We have a Lemon test. Lemon versus Kurtzman is the court case. Money given to religious schools. Does the law have a secular rather than a religious purpose? Does the law neither promote nor discourage religion? And does the law avoid excessive entanglement of the government and religious institutions? Protections of the accused. We have double jeopardy, right to counsel, speedy trial, impartial jury, unreasonable search and seizures, excessive bail, cruel and unusual punishment, and self-incrimination. Now we come to the exclusionary rule. It's the part of the Fourth Amendment, search and seizure, and Fifth Amendment. In 1961, Mapp v. Ohio incorporated the Fourth Amendment and established the exclusionary rule. Has to be a legal search. A warrant has to be issued by a judge with probable cause in order to search and seize. There needs to be an arrest. Good faith exception, U.S. v. Leon. Inevitable discovery rule evidence that would have been found legally is allowed. Confessions. Involuntary confessions are excluded from trial, and you must be read your Miranda rights. Death penalty. The Eighth Amendment, cruel and unusual punishment. Some restrictions but upheld as constitutional. Furman v. Georgia in 1972, the court looked at the death penalty in the U.S. and found that it is often racist and arbitrary, and they halted the death penalty. However, in 1976, convinced the court in Gregg v. Georgia that it has a fair system for trying capital offenses, and it resumed the death penalty. Terrorism and civil liberties. The Patriot Act, which is a court order to tap any telephone of suspect, internet taps, voicemail taps, grand jury information released. Non-citizens can be held for 7 days. Money laundering investigations, and no statute of limitations. Executive order by Bush. Suspected terrorists can be tried in a military court and can be secret. Wiretappings without approval were revealed in 2005. Rasul versus Bush, Hamdi versus Rumsfeld, terrorist detainees have access to a neutral court. How to discuss a court case when in an FRQ. Don't spend too much time on the background of the case. The decision is what is important. Marbury versus Madison, for example, establishes judicial review.